This is Barry Zalma on Insurance on YouTube. I am a lawyer who has retired from the practice of law and spend my time now working as an insurance claims consultant and insurance expert witness. I can always be reached at my telephone 310-390-4455. Today, it's time to talk about lawyer ethics. The practice of law demands more than knowledge of statutory and case law that the lawyer be and conduct himself or herself ethically. It requires more than the technical proficiency in the nuts and bolts of legal practice. A lawyer is an officer of the legal system whose conduct should conform to the requirements of the law, both in professional service to clients and in the lawyer's business and personal affairs. The practice of law requires that every lawyer treat each client, each adversary, and the court ethically and in good faith. The practice of law is different from other professions because it requires that the lawyer act for his or her client, not him or herself, only if the actions for the client are ethical and in good faith. So what is ethical behavior? The concept of ethical behavior refers to the well-founded standards of right and wrong that prescribe what humans ought to do, usually in terms of rights, obligations, benefits to society, fairness, or specific virtues, all of which are essential to the lawyer. Ethics, for example, refers to those standards that impose the reasonable obligations to refrain from murder, rape, theft, assault, slander, and fraud. Ethical standards also include those that imply virtues of honesty, compassion, and loyalty. There are rights presumed to exist as those described in the Declaration of Independence, submitted to King George of England in 1776, that held, and I quote, "We hold these truths to be self-evident, that all men are created equal, that they are endowed by their Creator with certain unalienable rights, that among these are life, liberty, and the pursuit of happiness." Close quote. The unalienable rights also include the right to life, the right to freedom from injury, and the right to liberty. Such standards are adequate standards of ethics because they are supported by consistent and well-founded reasons that have survived the tests of time. Ethics also refers to the study and development of one's standards of conduct. Feelings, laws, and social norms can deviate from what is ethical. It is necessary, especially to people involved in the practice of law, to constantly examine one's standards to ensure that they are reasonable and well-founded conduct that ethically treats a client, an adversary, and the court with utmost good faith. Ethics also requires the continuous effort of studying our own moral beliefs and our moral conduct. The ethical lawyer must strive to ensure that we, as lawyers, and the institutions we help to shape, live up to standards that are reasonable and solidly based. To those in the practice of law who are compelled to deal ethically in everything the lawyer does in the practice of law, every lawyer who practices law is expected to develop a moral code of conduct that strives to ensure that every person involved in the practice of law and the representation of the lawyer's clients will shape and live up to standards that are solidly based in the good faith handling of legal representation, whether as a litigator or as a legal consultant. There is no single answer to the question of what is ethical behavior by a lawyer. Ethical behavior is subjective and fact-dependent. Philosophers over the centuries have created methods to act ethically. The concepts defining ethical behavior are different and unlimited. Philosophers have struggled with the concept of ethics for more than 3 eons. Few agree on which to use. Some apply various concepts depending on the fact situation. Those in the practice of law must avoid situational ethics. It should not and will not apply to the practice of law, whose only ethical mandate should be the need to treat clients, adversaries, and the courts honestly, fairly, and with good faith. In the times of ancient Greece, the virtue ethics of Socrates, Plato, Aristotle, the Epicureans, and the Stoics were very individualistic and primarily concerned with helping one person become a better person through self-improvement. Socrates believed that if you know right from wrong, then you might be able to choose to do what you know to be right. In his philosophy, no one does wrong voluntarily. Evil is the result of ignorance. If people knew what was the right thing to do, to Socrates, they would do it. Every lawyer must understand right from wrong in the practice of law. You cannot lie to a judge. You cannot treat a client unfairly. You cannot use a client's funds as if they are your own. You cannot treat an adversary unfairly. You cannot deal with the client or the adversary in a way to deprive either of the rights provided to them by the law. The ethical lawyer recognizes that a virtue is an excellent trait of character and one that is the goal of every lawyer. It is a disposition well entrenched in the possessor, something that goes all the way down unlike a habit, such as being a beer drinker, to notice, expect, value, feel, desire, choose, act, and react in certain characteristic ways. For a lawyer to possess a virtue is to be a certain sort of person with a certain complex mindset that applies the law, both statutorily and precedential, fairly and effectively. A significant aspect of this mindset is the wholehearted acceptance of a distinctive range of considerations as reasons for action. An honest person, an honest lawyer, cannot be identified simply as one who, for example, practices honest dealing and does not cheat. If such actions are done merely because the lawyer thinks that honesty is the best policy, or because they fear being caught out rather than through recognizing that to do otherwise would be dishonest, an honest person cannot be identified simply as one who, for example, tells the truth because it is the truth. For one can have the virtue of honesty without being tactless or indiscreet. The honest and ethical lawyers recognizes that would be a lie as a strong, though perhaps not overriding reason for not making certain statements in certain circumstances, and gives due but not overriding weight to, well, that would be the truth, as a reason for making them. An honest lawyer's reasons and choices with respect to honest and dishonest actions reflect his or her views about honesty, truth, and deception. But of course, such views manifest themselves with respect to other actions and to emotional reactions as well. Valuing honesty as a lawyer does, he or she chooses, where possible, to work with honest people, to have honest friends, to bring up his or her children to be honest. The lawyer disapproves of, dislikes, and deplores dishonesty. He or she is not amused by certain tales of chicanery, despises or pities those who succeed through deception rather than thinking they have been clever, is unsurprised or pleased as appropriate when honesty triumphs, and is shocked or distressed when those near and dear to the lawyer does what is dishonest. Possessing of virtue is a matter of degree. The Socrates of Plato's dialogues devotes a great deal of time to asking his fellow Athenians to explain the nature of virtues like justice, courage, piety, and wisdom. What is not open to debate is whether Plato has had an important influence on the contemporary revival of interest in virtue ethics. The defining feature of Platonistic virtue ethics is to be that a good agency in the truest and fullest sense presupposes the contemplation of the form of the good, constantly attending to our needs, our desires, our passions, and our thoughts, skews our perspective on what the world is actually like, and blinds us to the goods around us. Contemplating the goodness of something we encounter, attending to it for its own sake in order to understand it, breaks the natural tendency by drawing our attention away from ourselves. A lawyer following Plato's virtue ethics should contemplate such goodness with regularity and make room for new habits of thought that focus more readily and more honestly on things other than the lawyer's self. The purpose of every lawyer is to serve others. In so doing, the lawyer coincidentally serves himself or herself. The virtues get defined then in terms of qualities that help one pierce the veil of selfish consciousness and join the world as it really is. As a result, the good agency of the lawyer is defined by the possession and exercise of such virtues. The kind of goodness which is possible for humans is defined by virtue, and any answer to the question of what one should do or how one should live will appeal to those virtues. Mehta Ethics, on the other hand, concerns and questions raised from antiquity. Plato asked how one would recognize the solution to a problem, and that would include a meta-ethical problem such as, what is justice? Unless one already knew the answer in some way. Plato also proposed answers to the question, why should I be moral? Can there be a universal ethics? Although he used different terminologies for them, the Republic contains his attempts to answer those questions. Aristotle raised meta-ethical questions in his Nicomachean Ethics throughout the history of philosophy. Since then, any philosophy who has raised such questions as, where do ethical norms or values come from? How could an ethical theory or norm be defended? Or any other from the list of questions, meaning almost every philosopher who has done work in ethics has dealt with meta-ethics, at least to some extent. In the 20th and 21st centuries, philosophers dealt far more with meta-ethics than with normative ethics, and many of them dealt only with meta-ethics. There is also a counter-trend that is seen and expressed in the ongoing growth of normative theory, especially in such fields as business ethics, medical ethics, and international ethics. Meta ethics is the attempt to understand the metaphysical, epistemological, semantic, and psychological presuppositions and commitments of moral thought, talk, and practice. In the practice of law, the lawyer can only apply meta-ethics when the system involved is the application of the law as written and as recognized by legal precedent. Moral realism, a concept of meta-ethics, holds that there are objective values. Realists believe that evaluative statements are factual claims, which are either true or false, and that the truth or falsity does not depend on our beliefs, feelings, or other attitudes towards the things that are evaluated. Moral realism can be contrasted with moral relativism, which can also be called normative relativism. Moral realism comes in two variants: ethical institutionism and ethical non-naturalism hold that there are objective, irreducible moral properties, such as the property of goodness, and that we sometimes have intuitive awareness of moral properties or moral truths. Ethical naturalism, on the other hand, holds that there are objective moral properties, but that these properties are reducible to entirely non-ethical properties. Most ethical naturalists hold that we have empirical knowledge of moral truths. Several have argued that moral knowledge can be gained by the same means as scientific knowledge. It would be impractical for me to deal with every type of ethics available to help the lawyer understand what is appropriate in the practice of law. Some of the other types of ethical categories include the Golden Rule, first stated on a mountaintop in Jerusalem. Kant, Immanuel Kant, the German philosopher, who created a system known as the categorical imperative. His contemporary, Hegel, another German philosopher, came up with a theory called the ethical life. There is also understood by philosophers applied ethics, altruism, pure reason, Ayn Rand's rational self-interest ethics, the utilitarian principle, and the insurance theory of utmost good faith. What concept of ethics best fits the lawyer depends entirely on the lawyer. And for that reason, I have written the little book on ethics for the American lawyer, which is available on Amazon.com as both a Kindle book and a paperback, and can also be found with links on my website, www.zalma.com, by linking on the insurance claims library that is noted on that site. Thank you for your attention, and I hope this has given you some indication of the type of ethical behavior that is required of every lawyer practicing law in the United States.